So everyone in the legal fraternity would always name this case as D.K.BASU only. But the case name is not just the D.K.BASU. The full name of the case is that is Shri D.K.BASU Ashok J. Jori versus State of West Bengal and State of Uttar Pradesh. Judgment of this case was given on 18th of December 1996. Though it being a 90s judgment, it still has relevancy for the current period. So the judgments were delivered by Honorable Justices Kuldeep Singh and A.S. Anand. This case is not just about one incident that took place and suddenly a case comes up before a court. It was not like that. The situation was different. Two incidents took place in two different territory, that is locations, and one is in West Bengal and another is in Uttar Pradesh. So two persons in different locations have given information regarding the custodial torture that they were subjected to, and two chief justices belonging to their respective high courts have taken cognizance and made it as a single case. So the facts of the case are as follows: like D.K. Basu is an executive chairman of Legal Aid Service of West Bengal. He has written a letter on 26th August 1986. He has written the letter to Chief Justice of India, that is then Chief Justice of India, P.N. Bhagwati. He is also known to be a father of public interest litigation, and that letter he had highlighted some news items that were happening due to police lockup and police torture and custody. Along with those documents, he had also instructed the judges to treat it as a public interest litigation or a writ petition, right? So the court took cognizance on this letter, and the letter was treated as a writ petition due to its seriousness. And the notice was issued to the respondent on 9th of February 1987 by the court. And now comes the Ashok Joris into the picture. He made a letter on 29th July 1987 and sent it to the then Chief Justice of India, R.S. Pathak. So Ashok Kumar has highlighted in that letter saying that there happened a custodial torture by the police. So the place in which the torture has taken place was in Aligarh, and that custodial torture has resulted in the death of a person who was named Mahesh Bihari. So now the court has treated this letter also as a writ petition, and the court directed that the writ petition will be listed alongside with the D.K. Basu's petition. So after this hearing took place for a while, and court came up with some guidelines regarding the prevention of police custodial torture. So these are some of the guidelines regarding the prevention of police custodial torture. First comes the identification tag. The police person who is arresting should wear a name badge in a way that it is clearly visible to every person, also to the person who is getting arrested, so that he will be aware uh, to whom he is getting arrested, right? And secondly comes the memorandum of arrest. So memorandum of arrest will be prepared, and it will be signed by the witness. So the witness would be most probably the family members and any local person who's a respectable person. And memo should also be signed by the person who's getting arrested, and the date, time, and the place of the date and time regarding the place of arrest must be mentioned. Thirdly, information regarding the arrest must be sent to the relatives of the person who's getting arrested. If relatives are not available, to their friends. And then comes the notification. So if in case the relatives of the person who's getting arrested live in another town or area, then the information regarding the arrest must be communicated within 8 to 12 hours, and it should be done through a legal aid organization. So the person who is arresting the accused should ensure that these guidelines are complied with. And then comes the right to information. Under this right, the police officer should inform the accused person, saying that you have right to notify about your arrest uh, to your relatives or friends. So police officer should uh, inform the accused person that the accused person has this right, that is right to information. And then comes the diary entry. So the time and the place of arrest, along with the details of the policeman who's arresting the accused person, should be recorded in a diary. So that diary is called detention diary. And the person to whom the information regarding the arrest was communicated, that person's name should also be mentioned in that diary. And next comes the medical examination. So the person getting arrested, if he had sustained some injury during arrest, it it should also be recorded at the time of arrest, and it shall be recorded in that inspection memo, which that inspection memo will be signed by the person who's getting arrested, as well as the person who's making that arrest. So most probably it will be the policeman who will be signing. Also, the accused, the person who's getting arrested, his sign is also necessary in that inspection memo. And next comes the regular medical checkups. So the accused person must be medically examined every 48 hours by the panel of directors who are appointed by Director of Health Services. And next comes the document submission. So all these documents, that is copies of arrest memo and related documents such as inspection memo and detention records, all these documents must be sent to the magistrate. And next one is uh, right to meet the lawyer. The person getting arrested can meet his lawyer during interrogation, but should not happen throughout the investigation. The law and order agencies, that is enforcement authorities, must be given some space in order to continue their investigation. But the person getting arrested still has right to meet the lawyer during investigation. So that is very clear. And the last one, the last guideline, control room display. The details regarding the arrest. The person he got arrested by the policeman. Now the custody details, his custody details must be mentioned in the police control room within 12 hours of the arrest. So these are the 11 guidelines that has been given by the Supreme Court in D.K. Basu's case. The court has also stated that if in case these guidelines are not complied with by law and order authorities, then in such case departmental actions of course can be taken against the person who are not complying with the guidelines, and even contempt proceedings can also be initiated against them. So these are, the court held these things, and we can safely assume that court delivered all these guidelines deriving from articles 21 and 22 clause 1 of Indian constitution. Yeah, these are the key takeaways that I've mentioned. So basically, whenever D.K. Basu case comes to your mind, it is basically regarding the custody and detention by the police, and to prevent custodial tortures and deaths. Yeah, that's about the video.